Supreme Court, in a path-breaking order, has stayed the decision of the Karnataka government. SC directs that the Karnataka government's decision scrapping 4% quota of Muslims will not be implemented till May 9th, which is still the campaigning, the last day of the campaigning. The Supreme Court adjourned the hearing of a petition challenging the Karnataka's government's decision to scrap the 4% reservation provided to them under the other backward class category, which has been in place for almost 3 decades. Now, the hearing is adjourned till May 9. The bench also noted an assurance given by Solicitor General Tushar Mehta that the earlier regime regarding the Muslim quota would remain in effect until the next hearing. And let me take you through the detail. The Karnataka government had issued a government order on March 27 removing the 4% quota for Muslims for other backward caste category. It turned into a campaign. A senior BJP leader in Karnataka said that the politics in Karnataka is Modi versus appeasement. The counsel for the Karnataka government assured the court that it would not take any decision on the appointment or admissions. Now, in the last cabinet meeting ahead of the Karnataka Assembly election, Basavaraj Bommai government had taken this decision. This has turned into an election plank. That 4% was divided into 2%. And that 2% had gone to the Lingayats and the rest went to the Voka-Liggas. Lingayat is the backbone of the Bharatiya Janata Party's politics in Karnataka, and Voka-Liggas are the backbone of Devegowda's party. But this time BJP had set its eye on the Voka-Ligga vote, which means the southern or the greater Mysore region. On this issue, I am joined by my legal editor Ashok Bagaria and our political editor Brijesh Pandey. Just to set the debate, just to set this order, in your opinion, why has court taken this decision?
Well, usually courts pass such a blanket order when they prima facie see merit in the arguments or the petition which has been filed before the Supreme Court of India. Now, in this particular matter, there are a lot of things that have been happening since February when this petition was filed in the Supreme Court. Repeated adjournments were being taken by the Karnataka government. Now, yesterday and today again, when the Solicitor General and the Karnataka government sought an adjournment, an objection was raised by senior advocate Dushyant Dave, who said that for the last 4 occasions, the Karnataka government has been taking simple adjournments, not filing affidavits or clearing its stand on the issue of scrapping 4% reservation for Muslims under the OBC quota. So here the situation today is that on one hand, we are just at the threshold of assembly elections in Karnataka, and this 4% OBC reservations for Muslims under the OBC quota, which has been scrapped, was redistributed to Lingayats and Voka-Ligga communities, probably to pacify the communities, these communities which constitute an important vote bank for the Bharatiya Janata Party. Now today, the Supreme Court said that they are going to stay the Karnataka government's order which scrapped 4% reservations for Muslims under the OBC quota. This came after the Solicitor General of India, Mr. Tushar Mehta, gave an oral promise, made an oral promise to
Ashok, on 14th of April, I would like to read this out to you. The Supreme Court said that the government order is based on completely fallacious assumption, quote unquote. Prima facie, the order passed appears to suggest that the foundation of a decision making is shaky. Justice K.M. Joseph. Why did he say that?
Well, see, basically, when you include or exclude any community from the other backward classes, there has to be a data on the basis of which you can take such a decision. It cannot happen at the mere whims and fancies of the government in power, that saying that, okay, this is a thing that has been going on for the last 30 years, and we today decide at the threshold of the Karnataka Assembly elections, we decide that we are going to scrap this reservation. Now, this particular matter had come to Supreme Court in February, and the matter was referred to a constitution bench. And there, the issue raised, exactly the same issue, one of the Muslim parties who approached the Supreme Court said that there is no verifiable data with the Karnataka government to scrap these reservations which has been there for the Muslims for the last 30 years.
Okay, and let me ask this question to you before I shift my debate on the political ground to my friend Brijesh. Isn't it correct that under Indian Constitution, the reservations in backward category is only for Hindus who are SCs and STs? It is not given to the Muslims?
Well, the constitution basically envisages three types of reservations. First for scheduled castes, second for scheduled tribes, and the third for other backward castes. Now, as far as the other backward castes are concerned, traditionally the other backward castes have been Hindus, and they have largely got the benefit of this OBC reservation. It was the Karnataka government who 30 years back said, no, we are going to cut across religious lines and extend the benefit of these reservations to Muslims also.
But what about Dalit Hindus? Tamil Nadu mein hota hai, Dalit Christians. That opens up the Pandora box.
Of course, there is a parallel petition which is pending before the Supreme Court where Dalit Christians, Dalit Muslims have also approached the Supreme Court saying that, you know, there is a strange situation in the country where these people have converted from Hinduism to other religions like Christianity and Islam. But there is a peculiar setup in the Indian subcontinent where the saying, jati hai par jati nahi, in the sense that even if you have converted to another religion, the caste system grip is so strong that it doesn't go. So these are very socially sensitive matters which are pending before the Supreme Court. The Dalit Christian, Dalit Muslim issue is also before the Supreme Court. This issue of 4% reservation, you see, the 4% reservation is more tricky because some 30 years back, the government decided that we are going to give 5% reservations to the Muslims. Now suddenly 30 years later, you wake up and say that, okay, we don't think that these Muslims need 4% reservation, we are going to scrap it completely. But that scrapping also has to be based on some data. There has to be a data to suggest that in the last 30 years, these Muslim communities who have got the benefit of reservation have so benefited that they have moved up the social stratum.
Okay.
And that's why they do not need reservation.
Okay.